Okay, folks, we are now in Law of Contracts, Chapter 21. This chapter has to do with title, risk, and insurable interest. Title, when we're using it in this context, and now again we're particularly in the part of the course that deals with the UCC, so we're talking about title to goods, whether they be goods being sold or goods being leased under Article 2 of the UCC. Title is legally recognized ownership of the property. This becomes a critical question, particularly when we're moving goods about the country. Who owns the property at a particular moment in time can be a very critical determination. If the property is destroyed, who bears the loss? Who can recover from insurance for the loss? If the property injures or damages a third party or their property, who is responsible? Who will have to make good for that injury? Can creditors seize a piece of property? Depending on who owns it would be part of the determination as to whether a creditor could come and take that property to satisfy an outstanding loan or an outstanding judgment. Who has the right to transfer? Just because someone is in possession of property doesn't mean they have the right to sell it. If I lease a piece of office equipment from my office, I can't turn around after I've had it for 3 months and sell it to somebody else, even though it's in my possession, even though I'm using it, even though it looks like it's part of what belongs in my office. It's not mine. It's a lease. So questions come up more and more all the time as we come up with more and more interesting ways to deal with personal property as to who is the owner at a particular moment in time. The UCC attempts to bring some order and rationality to this. I'm not sure that they exactly get that far in what they do, but we're going to go through in this chapter some of the basic rules about how do we tell who has title, who is the owner of property at any given moment. All right. Two different concepts come into play when the UCC tries to determine who has title to property. The first concept is existence. Existence is easy. It means the same thing under the UCC as it does in everyday language. Does this item exist or does it not exist? Now you could say to me, Mr. Walsh, what do you mean not exist? There are things that do not exist but yet are the subject matter of contracts. If you are contracting with somebody to manufacture an item, at the moment you are making your contract, that item does not exist yet. It has to be built. It has to be manufactured. A large part of our economy in this country is based on farm production. There are animals that are not born yet. There are plants that are not planted yet. Crops, corn, wheat, soybean, hogs, chickens, cattle. All are things which can have a future existence, and we can be signing contracts for them now. I assure you, all the wheat that is being planted and is corn being planted now or about to be planted throughout the Midwest and the Great Plains has already been bought and sold by and large. There are already contracts existing with companies who are going to come and take that grain when it's ready for harvest and use it for their different purposes. The seed hasn't even been put in the ground yet in many cases to create the new plants, to create the new crop. But we can have contracts that deal with these items. So, in terms of dealing with ownership, the other concept is identification. Identification is when goods are set aside or somehow marked or earmarked to be subject to a particular agreement or contract. So they may not have left the seller's place of business yet. They may not have moved 1 inch from where they have been sitting for the last 6 months, but a buyer has come along, said, I want to buy X, has entered into an agreement with the seller, and the seller now somehow identifies or sets aside or moves these goods or in their inventory computer, marks them in such a way so that we now know these goods are to be applied to this contract. All right. Under the UCC, no interest in goods can pass to a buyer until they have been identified to the contract. All right? So they cannot be the buyers cannot have any claim to them. They can't insure them. They're not responsible for them until the goods have been identified. Once the goods are identified, that doesn't mean title has necessarily passed. The seller still, if they haven't been paid, if they haven't shipped them, still might be the owner of the goods. However, at that point in time, the buyer is now tied into the contract. Goods exist that are intended to fill the contract. And at a minimum, the buyer now has what's called an insurable interest in the property. They have the right to buy insurance at this point, so that if the goods are damaged or destroyed somehow, the insurance company will cover and pay for whatever loss the buyer might incur. This is an important reality because insurance is a funny thing. We don't go into it greatly here, but it is a form of contract, and it is a highly regulated form of contract. One of the realities about insurance is that for centuries, the courts and the statutes, the legislatures and state regulations have held that you must have an interest in property to insure it. Meaning that I cannot insure my next door neighbor's house against having it burned down from fire. Since I have no right to that property, no interest in it, the courts have long held that I would merely be gambling if they allowed me to take out an insurance policy to cover someone else's property. So in order for me to have a valid insurance contract, I have to have an interest in the property. Well, the UCC has given at least a partial interest in the property to buyers once they've entered into an agreement with the seller and the seller has done something on their side to identify goods to that contract. The buyer now can insure the goods to protect themselves from any potential loss of the goods themselves or of lost profits, lost income, lost carrying on of their business by failure to get the goods. Now, when our goods are identified, again, usually it is something that the seller does in their bookkeeping, on their computers, stamping the goods ready for delivery, putting them aside in the warehouse. However, the parties in their agreement, as with almost everything else in the under the UCC, they can decide when the goods will be identified, and they can place language in the contract that covers identification. If they don't do that, then again, the UCC has several fallback rules to apply to let us know when identification occurs. If goods are existing and they are in the seller's place of business, then they are identified the moment the contract is made and is entered into. If the goods are future goods presently not in existence, then if the agreement is for animals to be born within a year, at the moment of conception, there is identification. If the contract is for crops to be planted within a year, identification occurs when the crops are planted, so when the seeds are put in the ground. In other situations, the crops are identified when they begin to grow. With other future goods, the identification occurs when the seller ships, marks, or again otherwise designates the goods as subject to this particular contract. If goods are part of a large mass, so if we're dealing with what's called fungible goods are where every single piece or unit looks exactly like every other piece. Now, historically, this was applied to grains. Every grain of wheat, every grain of corn, every grain of oats was deemed to be exactly like every other. So even if you had the grain from 8 or 9 farms mixed in a silo, you as a buyer couldn't demand, I want Farmer Smith's grain only. All the grain was deemed to be fungible, to be exactly alike. With the advent of mass production, industrial production, manufactured goods in the last century also became fungible. If CCRI were to order all new chairs for its Warwick campus for the students, they're buying thousands of them from a producer who probably makes millions of them. So again, you have multiple goods, and you might have a warehouse with several million chairs sitting in it when CCRI is going to order 5,000 of them. With fungible goods, right? Identification occurs again when the contract is signed, so that the seller does not have to take their warehouse and start segregating the goods into little piles of this goes to contract A, this goes to contract B, this goes to buyer C. They can leave the fungible goods all in the silo if it's grain, all stacked up, and 100 chair-high stacks in the warehouse, and just by virtue of the fact that they made a contract, they know that a certain number of these are part of that contract, and they are therefore deemed by the law to be identified to the contract, and the buyers therefore have at a bare minimum not full ownership or title, but they do have an insurable interest that they can protect. Now, the parties, again, in their agreement, they can state when title is to actually pass. All right. Normally, that would be when the seller performs by delivering the goods. What constitutes a delivery depends very much on the type of contract. And if they say nothing in the agreement, then the UCC says that when the seller delivers the goods, then the buyer now has title. However, delivery is between merchants in particular is not what we think of as delivery from somebody like Amazon or eBay to a consumer. It's a little bit different concept. Now, there are different types of contracts, and that have to do with delivery, and they vary based on who is responsible for the delivery, and again, depending on who is responsible for delivery determines what time did ownership or title actually pass, at what point did it pass from seller to buyer. There are shipment and there are delivery contracts. In a shipment contract, the seller has performed when they have handed the goods over to a common carrier like UPS or FedEx. In a destination contract, the seller's duties are not complete, there is no delivery, and title does not pass until the goods are tended at the agreed upon destination. Now be very careful here, because it sounds like one of these means that as soon as the seller hands the goods off to the FedEx carrier, they're done. They can shake their hands and say, oh, we get our money, now we're done. But on the other one, somehow they have to make sure they get all the way to the buyer. That's not necessarily so. The agreed upon destination could be seller's place of business. And if the agreed upon destination is seller's place of business, then the seller is done as long as the buyer has arranged for some type of transport, some type of pickup. When the seller makes the delivery to that transportation at their loading dock, then they have made a tender, and the goods have been transferred, and now that the goods are at the buyer's disposal, they belong to the buyer. In situations where the delivery is to take place at seller's place of business, again, we talked in the last chapter about tender and how does tender affect the performance under a contract. If the buyer is supposed to be picking up the goods at seller's place of business on a specific date at a specific time, once the seller has made those goods ready for transport, put them on the shipping deck, and made them available for the buyer to pick up, title has passed to the buyer. Those goods now belong to the buyer, even though they're still in seller's possession. So if a tornado were to roll along the plains and wipe out the seller's building at that point in time with the goods in it, if the seller can prove he had actually set them up for delivery and put them in place, and the buyer had not shown up at the appointed day and time to pick them up, and the seller left the goods there waiting for the buyer would bear the risk of loss. The buyer would need to be the one to have insurance to pay for the damage that was done. Sometimes goods require title documents, so they have title documents. This is particularly true of in the agricultural business when you're dealing with grains and other foodstuffs. Again, a number of small farmers may all place their grain, their produce, into a common silo or common storage area, and in exchange for that, they are given a warehouse receipt for the goods that they have placed in storage. Very often, those title to those goods can be transferred by assigning the warehouse receipt, so that the farmer can send the warehouse receipt to the potential buyer. The buyer sends the money to the farmer, and as soon as the buyer is in possession of that warehouse receipt, the receipt means they are the ones who can now go and pick up the goods at the warehouse. The farmer no longer is able to, and therefore they are now again the owner, and they bear the risk of loss, even though the farmer has done nothing except deliver the goods to a silo and then go looking to a company that will hold them in a silo as a warehouser, and the farmer then goes looking for a buyer. So the farmer does not have to move the goods any further. The risk of loss and the title will have passed. have to be very careful because there are warehouse receipts that are title documents. There are also some things called bills of lading, which are just shipping contracts, which do not change the title, but they just indicate who is going to pay for the shipping, who's responsible to pay the carrier. Section 21(2)(c) talks about sale or lease by non-owners. Basic rule here is the same as in real estate law, property law, and common law, which is that if you don't own it, you cannot sell it. If you don't have good title to it yourself, you cannot create title in someone else. If the goods were obtained by fraud, if payment was made and dishonored, if the goods were purchased on credit from an insolvent seller, if they were stolen, in many cases the title is not good and the holder or present holder of the goods is not the owner and cannot transfer title to another person. One exception to this is a bona fide purchaser or a good faith purchaser, and this rule is in place mostly to protect consumers, but it also does protect merchants to a certain extent. A good faith purchaser is one who buys in the ordinary course of business for consideration, so we're not talking about gifts, in good faith, without knowledge or notice that there was a defect in the title. Someone who does that becomes the owner of the property. Many of you probably do not realize unless you work in the industry, but in supermarkets, many of the shelves in the supermarkets, particularly having to do with the fast foods and snack food aisles, the supermarket doesn't own those things. Each company has a certain amount of shelf space that they're allowed by the supermarket. They place their goods there. The supermarket uses their computers at the registers to keep track of the goods. The supermarket takes out a certain commission for selling the goods and then sends the rest to the company at the end of the month. However, any goods that are not sold have to be retrieved. Baked goods, certain types of produce, certain types of frozen goods, and certainly most of the snack food type goods fall under these categories. The markets do not want to be responsible for unbought goods that become stale, so they basically leave ownership with the manufacturers who have to deliver these goods, put them on the shelves, and then come by every couple of days and take out the ones whose dates have expired. And the market is not responsible for paying for those. In that type of situation, the market does not own the goods. However, the market is the one who's selling them to you. You as a consumer have no idea this is going on. So as long as you buy those goods from a regular market, a regular convenience store, in good faith, with no knowledge that the goods don't belong to the market or that the market owes money on them still, then you take title to them free and clear, and the original owner cannot come back against you. They have to go against the merchant. If goods have been entrusted, entrustment, which we also call bailment under the law of property, is when you give your property to a third party for a particular purpose on a contract. So you bring your watch in to be repaired, you bring your clothes in to be cleaned, you leave your pet at the animal boarding place while you go on vacation. In all of these instances, you are not giving up ownership of the property. You are giving the property over to a third person to hold for a particular purpose. So those folks are called the entrustees or trustees, and they are being entrusted with your goods. If they are engaged in the sale of goods, let's say you bring your watch into the watch jewelry store to be repaired, and they also sell fine watches. If by mistake they sell your watch, it could be deemed that the buyer is a bona fide purchaser. They get to keep the watch. You get to sue the shop for the value of the watch, but you may not get the original watch back. Risk of loss, all right, is an important idea because if goods are destroyed, insurance companies are not going to pay for them 3 times. The people who did damages to them are not going to pay for them 2 or 3 times. So it's critical to determine who owns the goods, who bears the risk of loss. Those are the folks who need to be insured. Those are the folks who would have to file suit to recover against somebody who had damaged the goods. And again, this can be expressly stated in the agreement between the parties, and it should be, but it isn't always. So sometimes the UCC has to fill in. If there is delivery with movement of the goods, all right, then the goods look to the delivery terms to see when the risk of loss comes into play. In a shipment contract, as we said, the seller is required to pay for shipping, get the goods to a common carrier. At that point, risk of loss passes to the buyer. In a destination contract, risk of loss usually does not pass to the buyer until the goods reach a specific location. Again, if you look at an exhibit on page 396, Exhibit 21-2, there's a pretty good graph or diagram of this. There are some specific shipping terms that are used. And the UCC, these existed before the UCC. The UCC adopted them because they were in such prevalent use that they basically took them and put them into the statute. And basically, they're a shorthand. If you have a contract that's free, FOB, free on board, it means the selling price includes shipping costs to the place named in the contract. That could be the seller's business or it could be the buyer's business. So free on board could be either a shipment or a destination contract, depending on further terms in the agreement. But it does mean that whatever the shipping agreement is, it's up to the seller to pay the costs and get the goods to the deliverer. Free alongside means the seller agrees to deliver goods to a carrier. This is usually used in situations where ships are involved. Alongside means that you get the goods to the dock because you're normally not allowed to go drive onto the boat to drop off your goods or whatever. So free alongside means that you get the goods to the carrier and then the seller's duty is done. The risk of loss would pass to the buyer. CIF or C&F, cost insurance and freight or cost and freight. It means that the seller puts the goods in possession of a common carrier and that the price of the goods included the cost of the goods, insuring them and shipping them. Cost and freight means the seller's not going to insure the goods, they're just going to pay to ship them, and the risk of loss would pass accordingly. So if the seller is insuring the goods, the seller maintains the risk of loss until delivery is made. If the seller is not insuring goods, then the risk of loss passes to the buyer. Again, 21(3)(b) talks about bailments. A bailment is a transfer of possession of property without transfer of title to a third party. The bailor is the one who owns the goods and gives up possession. The bailee is the one who receives the goods. And usually these are situations where they are a commercial reality and you are giving the goods up for a particular purpose, like having your clothes cleaned or having your furniture shipped across state lines to your new house or whatever. If a seller keeps goods for pickup by the buyer, the risk of loss passes at the moment of tender, at the moment the goods are made available to the buyer. Now, between merchants, it could be that the risk only passes when the buyer picks them up. But if you're not a merchant and you've agreed to pick up the goods, whatever time or date you said you would, the risk of loss has passed to you. All right. Normally, the risk of loss passes to a lessee upon delivery to the lessee when you have a leased goods situation. Most of these contracts have come into being most recently, and they're very tightly written by attorneys. And again, in their provisions, even though the lessor remains as the owner of the property, as part of the lease agreement, and particularly if you think of leasing an auto, leasing a car, you as a lessee are responsible for the insurance. You must buy it, pay for it, and you must make sure that it always covers the market value of the car and hasn't gone below, that the market value of the car is not higher than the amount of the insurance. And again, that it's usually done by express agreement in the leases. We talked a little bit already about negotiable title documents, so that when things are put into a grain elevator or a warehouse, there can be a title receipt, a warehouse receipt that's issued for them, and the warehouse receipt basically allows whoever holds it to come and pick up the goods and remove them from the warehouse. If they are negotiable title documents, then the risk of loss passes to the buyer at the moment the buyer receives the documents, because at that point in time they have the right to go and pick up the goods. The bailee, the warehouse holder, has to acknowledge the buyer's right to possess the goods, or If the buyer receives a non-negotiable document of title, then they must notify the holder of the goods that they now have taken over the property. And if the person holding the goods refuses to release them, then the risk of loss stays with the seller. So the idea here is, if you're using negotiable documents, the minute that piece of paper goes from seller to buyer, the buyer is now responsible because the warehouse people have to give the goods to whoever shows up with that piece of paper. If it is a non-negotiable, just a warehouse receipt, there could be some issue because the warehouse person could say, wait a minute, seller A put these goods in here, but now you're B holding this piece of paper saying you have the right to them? How do I know that? So it involves notice. The seller should give prompt notice to the warehouse person that they have transferred the goods to B, and B should give prompt notice to the warehouse person that they're now my goods, I intend to pick them up. And if the warehouse person is going to get difficult over it, then B turns back to the seller and says, you have to talk to these people and let them know that I now own the goods and I can pick them up. And until there is recognition of that by the warehouse person, the risk of loss remains with the seller. Now, there's something called a conditional sale or a sale on approval. And these happen quite often in business, particularly where they're highly competitive, things like for photocopiers and printers and computers, where the merchant, the seller, is willing to let the buyer take the goods on a trial basis. And the risk of loss remains with the seller until the buyer makes final acceptance. So really, these are almost like a loan or a lending situation without consideration. So if the buyer decides to purchase the good, they must notify the seller if they decide that they are buying them and pay for them. If the seller refuses to retrieve the goods, the risk of loss remains with them, and the buyer doesn't have any worries about them. The minute the buyer pays for the goods, they become the buyer's goods. They now have the risk of loss. If the buyer takes those goods for resale, such as a consignment shop, and they are not sold within a reasonable time, they can be returned to the seller. The risk of loss passes to the buyer on delivery of the goods and remains with the buyer until the buyer actually returns them to the seller. So in a consignment situation, if you give your goods over to a consignment shop, they may not realize it, but the reality is the risk of loss passes to them. If the goods are destroyed, they're responsible for them until such time as they have determined we can't sell these goods or we don't want to handle them anymore. And if they tell the person who put the goods on consignment, come get them, the risk of loss then passes back to the seller. And if the seller doesn't get them and the goods are destroyed, it doesn't matter. The risk of loss is on the seller at that point. Now, what happens if the contract is breached? Does that affect what happens to the risk of loss? If the seller breaches, the seller sends goods that are non-conforming, they don't meet the contract, then the buyer has a right to reject them, and the seller bears all risk of loss from the point of rejection. All right? Risk of loss does not pass to the buyer unless the defects are cured in a reasonable time or the buyer decides to accept the goods in spite of their defects. If a buyer accepts goods but then discovers defects that makes the goods non-conforming, acceptance can be revoked. And the revocation moves the risk of loss back to the seller. Similar rules apply with leases. If a non-conforming item is shipped to the lessee can reject it, and the risk of loss remains with the lessor at that point. If the buyer breaches, the risk of loss passes to the buyer immediately. The goods must have been identified to the contract, and the buyer only bears risk for a commercially reasonable time. That is, the seller must attempt to resell the goods, must attempt to mitigate, and the buyer is only responsible to the extent that any loss is not covered by the seller's insurance. So that's an interesting scenario. If you sign a contract to buy goods and refuse to accept them, you could still be responsible for them if they're destroyed and they never even attempted to deliver them, as long as they were identified to you. An insurable interest allows buyers and sellers to purchase insurance to cover potential losses. As we said above, a basic rule is that the insured party must have an interest in the property or they cannot insure it. And the basic idea is that you cannot recover double for any loss. So if both buyer and seller have insurable interests, then any settlement between their insurance companies would be split between them, and it would only be up to the actual value of the goods. It could not be a double dipping or a double collection here. Again, insurable interests for the buyers or lessees begin as soon as goods are identified to the contract. A seller's insurable interest continues until title has passed to the buyer. If the seller retains a security interest. Now, security interests are covered by Article 9 of the UCC. We don't really go into them here, but they are very interesting things. A security interest is basically a mortgage on personal property as opposed to a mortgage on land, which is a concept that people are more familiar with. So in very many situations, goods are bought on credit with a 30 or 60-day return payment, and as part of the agreement between the buyer and the seller retains what's called a security interest in the goods. So if they don't receive the payment on time, one of their options is to retrieve the goods. And in many states under the UCC, that can be done without judicial process. So it means it allows the seller to show up at the buyer's place of business and say, you didn't pay me for those items, I'm taking them back. If that is the situation, if there is a security interest in the goods, then the seller maintains or retains an insurable interest, because there's always a possibility they will not be paid for their agreement to extend credit, and that they would need to get the goods back. And of course, if the goods were destroyed, then the seller would lose. So because they have the possibility of being the loser here, the one bearing the risk of loss, they are allowed to retain an insurable interest under the law. All right, guys, that is it for Chapter 21.